Howitt, your turn.
So as I was thinking this morning about what to say to you, I couldn't help but think, if only I had had an opportunity to talk to Christopher that night of February 5th. If only I had had the opportunity to say, don't do it. Think about it. Think of the consequences. Do not be afraid of Sean and Charlie. There's other ways to handle this. Think about the risks to others. Life is precious, even though for those who are imperfect. But I didn't have that opportunity. I only have the opportunity to speak to you, to convince you to spare a life. It is tempting in this process to balance the value of the lives of the victims against the life of Christopher Vasata. It's tempting to balance the loss to the families and loved ones of the victims against the loss to Christopher's family. But the law does not give you that right. It is why the law channels your discretion, guides you in making this decision to not fall prey to those temptations. Because you see, the death penalty is not to be used for revenge or vindictiveness, is not to be used to place a value on people who have died. It's not to be used to balance a score. It is to be used as a last resort. A last resort for those who have committed crimes that are so aggravated and for which there is no reason for them to live. It must be very difficult for the families of Sean and Brandy and Kelly to sit here and listen to the last 2 days of testimony about Christopher and about his background and about who he is. But that's because it is only Christopher. It is only Christopher's life that you hold, that you can spare. I think it is always difficult to talk about taking of life or giving of mercy in the cold confines of the courtroom. It is inevitably emotional, and it is intended to be personal, both because it is necessary that you know Christopher, you know who he is, that you see where he came from, that you see how he got here. But it's also personal because each of you must make your own decision. You must make your own decision throughout the process of deciding this. This is a decision based on what you each individually believe, what you value, and what you feel. The law provides some process for doing that, and that is where we look to what the state has relied upon in asking for the death penalty, and that is the aggravating factors. So as the prosecutor told you, one of the aggravating factors established by Florida law is called prior violent felony or prior capital crime. That doesn't mean prior to this night. That means the crimes that were committed on that night. And what we know from that aggravating factor, and we're going to talk about it more when we're talking about mitigating, is there is no other prior violence in Christopher's life. The prior violence that is being relied upon is what occurred in that very short time on February 5th. The aggravating factor of cold, calculated, and premeditated. We know from the evidence the issues with Sean is what motivated this confrontation that night. The plan to kill Luke, and we know from your verdict you found Christopher is actually the one who killed Sean. But does that killing evidence the calm and cool reflection? And I would submit to you there is evidence that shows otherwise. The phone calls, back and forth, the texts just a few short hours before these horrible actions from Christopher. Sorry I haven't gotten back to you, to Marcus Stewart. I'm not well. I'll see you tomorrow. Does that reflect a plan, a careful design to carry out these crimes that night? I would submit to you it does not. As the court told you, an aspect of this aggravating factor is a pretense of moral or legal justification. That means it is not a justification whatsoever. But what we know from the evidence is that this crime was motivated out of the fear that Sean and Charlie were going to kill Luke. You heard about the plan, you heard about the discussion, you heard about the efforts to find him and to carry it out. But that'll be for you to decide. When the court reviews with you the verdict form, you will see that each of these factors apply to each count. You must decide it separately. And I would submit to you that this aggravating factor, as it applies to Brandy and Kelly's murder, is quite different. By your verdict, you found Christopher was not the one who shot and killed them. I would submit to you the evidence is debatable, whether Christopher even knew they were there in time for this heightened premeditation, this cool and calm reflection needed for this aggravating factor. While the prosecutor says, oh, they knew there was a strange car in the driveway, there's no evidence of that. What you did hear is that the car that was in the driveway was very similar to the car that Charlie Vorpagel drove. The fact that afterwards, whoever got the keys for that car didn't take them from Vorpagel, try to take Vorpagel's car, shows they believed, they thought it was Vorpagel's car, meaning that since they didn't try to take Brandy or Kelly's car, they believed it was Vorpagel's car and he'd left. He'd gotten away. The state has argued, but there has been no evidence that they were lying in wait for people, that they could see them in the backyard. What we do know is that Charlie Vorpagel kept a firearm by the front door, and so they did not enter through the front door. They came through the back. But there's no evidence to suggest they were there for any period of time, knowing who's back there, thinking about who's back there, thinking about this plan. There's no evidence that's inconsistent with them running to the back of the yard, without any idea who was back there. And we heard repeatedly how dark it was. The police who responded could not even see the people around the fire pit. In the backyard, they could not see. So to think that coming in and how quickly the shots were fired, that there was an opportunity for cool and calm reflection to take the lives of Brandy and Kelly is not supported by the evidence. And finally, the fact that Christopher was very seriously shot more than once during this shows there could not have been, in his mind, a plan, or he would not have been in the line of fire. Unlike the decision about guilt, the aggravating factors must only be determined based on what Christopher knew, intended, and did. The principal instruction that you were provided initially does not apply to these findings. The aggravating factor cannot apply unless all of you believe beyond all reasonable doubt that Christopher himself had a careful plan, a prearranged design, from a product of calm and cool reflection to take the lives of Brandy and Kelly. Your decision on this factual issue must be unanimous. And as I said, the finding is separate as to each. We talked about this during jury selection, and I will bring back the chart. So the finding on aggravating factors is just step one. If you do not unanimously agree as to the existence, your life sentence is imposed. If you do, you go to the next step, and that is the sufficiency of the aggravating factors. And sufficiency is about weight, importance, significance. This is an individual decision. This is a personal decision. It is only because, as we talked about in jury selection, significance, importance, weight may be different for everybody. And it is only if there's a unanimous agreement, all of you agree, that not only is it sufficient to go to the next step. If any one of you do not, a life sentence is imposed if that is the verdict. So, if you go to step 3, it is the weighing, again, the individual importance of the aggravating factors to the mitigating circumstances that we've been talking about for the last 2 days. I want to review with you what the court has read and the state has agreed have been listened. So this is a list, but again, you may have your own reasons. You may have your own reasons that life in prison is the appropriate sentence. But some things you may consider include but are not limited to. Christopher's neurological damage. It is undisputed. It is undisputed from the medical information that was provided to you that there is neurological impairment. Did it come from the car accident? Did it come from childhood sports? We don't know. But what we do know is it exists and it impairs his thinking in very specific ways. Impulsivity, impaired thinking, struggles with emotional control, difficulty foreseeing consequences, and immaturity. Another circumstance is his age, 24 years old. I would submit that that is combined with the other impairments in terms of his emotional age and his mental age being younger. Christopher suffers from anxiety, depression, and low self-esteem, a lifetime of self-harm to soothe the emotional pain that he has suffered all his life. A lifetime of hair pulling, and ultimately as an adult, developing a substance abuse problem, a drug addiction. We so often in this day have debates about the legality of marijuana as not a bad drug or not a serious health problem. But what you've heard is it can be. It particularly can be when it's made into a product that is so intense that it racks the body with illness, with violent throwing up, with a can't keep anything down, with the hot showers, the muscle pain, all of that. And we know Christopher suffered from it. We know it up to a week prior to the offense with the text that he sent Charlie Borpaper. He couldn't keep anything down. I would submit the drug addiction is really evidence of the emotional pain. The effort to soothe, the effort to escape, the effort to compensate for so many things that have gone wrong in his life. You heard a great deal about Christopher's upbringing because it is important to who he is. The abandonment and loss that over and over and over he felt with people who loved him, people he was attached to, people he trusted, people who cared for him, were taken from his life, unexplained and sudden. And we brought you, Ms. Brown, to talk about that from a therapist, but I don't know that you need an expert to tell you what that means to a person, what it means to lose those you love, not once, not twice, but over and over again. First it was his natural father, then it was his grandmother, then it was the person he's always considered his father, Juan. Then it was his mother when she left, leaving the children with Jennifer. Then it was Jennifer when she was cut out of his life. Then it was Danielle, who tried to bring the family back together, who tried to heal the wounds his family had endured. And then she, too, suddenly. And I think, as Ms. Brown said, and we probably know this, there comes a point where you start thinking, did I cause this? Is it something about me that is so unlovable, that is so worthless, that those who I believe love me do not stay, do not stay. This is significant also in terms of some of the things about Christopher that you've heard. His loyalty, his bonding with others, to his detriment and to many. Because what we know is he had no motive for these homicides. It was Luke. It was Luke that was afraid. It was Luke that was to be murdered. Why the loyalty? Why the protection? Does this help us understand that a little bit, perhaps? We know about his stepfather and sort of getting into the drug business. You know, I think thought throughout this case, if ever we get to see how complicated people are, it is what you have seen. From Sean, who was beloved, involved with his church, but also making very, very bad choices. And sort of, you know, it's just how complex people are. To Juan, who loved his children, and they loved him. But to Juan, never understanding why children should not be exposed to illegal activity. Why, when children are grown, you still should play a role as a parent on moral development. And that was not something Christopher was ever provided. Prior to this offense, he had no history of violence. This is a very significant issue. We talked about it in jury selection. Those who kind of felt like if you do it over and over again, it's another person, it's a Ted Bundy, where you do this murder, then a few days later you do another one, then you do another one. Or you have other violence in your history, robberies, assaults. None. Nothing. No prior violence. I told you at the beginning that we wanted you to see also that there is hope. There is hope in life. And so you can consider Christopher's kindness, his generosity to people in the past, and the kindness he can continue to offer people in the future. Christopher's capacity to continue to be a positive influence to his family and to others in the prison cell. These are just some of the reasons for a life sentence. And so I want to just add on that what I said to you in the beginning, you know, some of the testimony you heard that we provided was emotional, was hard to see people who love him, who want him to receive a life sentence, to hear nice things about him, but none of it was offered to excuse his crimes. None of it was offered for you to feel sorry and let that be what determines it. It was offered for you to understand who he is and how he came to be there. The photographs that we put in, for you to see different ages he was at when different events were occurring, so you could see the progress of his life. he is a complicated person too. So ultimately, you then weigh the aggravating factors and the mitigating circumstances. And it's sort of each step of this process, it becomes more and more personal. Because what might be important to you might be different for you. What might be important to you might be different for you. This is truly where we start saying, what do I value? What do I think? Finally, even if the aggravating factors exist, that the aggravating factors are sufficient, and I say you, all of you, that all of you individually agree that the aggravating factors outweigh the mitigating circumstances beyond a reasonable doubt. That high standard that we taught you. Then the final decision. Should it be a sentence of life in prison or a sentence of death? A sentence of life in prison means Christopher Vasata will never enjoy the freedoms we all hold dear. The freedom to marry, to have a family, to start a business, to eat when we want to sleep when we need to live with the people we want to live with, to make our most basic decisions over our lives. That's what life in prison means. And it means that every day for the rest of Christopher's life, and at 26, it's a lot of years, Christopher will have to live with the pain he has caused everyone. He will have to live with the pain he's caused the victim's family and the pain he has caused his own. He will live with that. This is as individual and personal a decision as you may ever make. The law allows you to have your own opinion, to disagree with others, and to be respected for your decision, because it is a decision you live with. It is a decision not of the whole, but of each of you individually. It is a decision that you have to know in your heart and mind is the right decision today, tomorrow, and forever. It is why it is why the law gives you the power to bestow mercy, even if you believe the death penalty is appropriate, even if you believe the death penalty is warranted. It is the greatest power a juror can ever have, is to bestow mercy. So the law provides, regardless of the results of each individual juror's brain process, even if you find sufficient aggravators, outweigh the mitigation. The law neither compels nor requires you to determine that the defendant should be sentenced to death. You may always consider mercy in making this determination. Mercy itself is sufficient to justify a sentence other than death. Mercy itself is a sufficient reason to spare Christopher's life. I ask for your mercy for Christopher. I ask you to value his life, to value it enough to allow him to live it out in prison rather than being put to death. I ask you this for Christopher, for the people who love him and the people he loves. I ask you for a sentence of life.